commentary on what appears to be a very challenging year for the Supreme Court. The Supreme Court may be anxious to portray itself as an apolitical institution, but this term political questions writ large are knocking at the High Court door. The upcoming term will almost surely be a march to the right on almost every issue that is a flashpoint in American society. Among them abortion, guns, gay rights, the separation of church and state, immigration, and presidential power. Also headed to the court are cases testing the power of Congress to get information from the executive branch and elsewhere, information that is relevant to congressional oversight and potentially to impeachment. Clearly, President Trump had something like that in mind when he said of the current impeachment inquiry, it shouldn't be allowed. There should be a way of stopping it, maybe legally through the courts. And if that isn't enough, pending before the court is a sleeper case, testing the very structure of our presidential election system. The Supreme Court, by tradition, has tried to stay out of big controversies in an election year. But the justices, even if reticent, don't always have control over their docket. When the lower courts are divided on major questions, the justices cannot always escape their responsibility to be the final decider. Here are themes to watch. Some justices are itching to play their conservative cards. The Supreme Court is a very different place since the 2018 retirement of Justice Anthony Kennedy, a centrist conservative, who often casts the deciding vote in closely contested cases. With President Trump's appointment of Justice Brett Kavanaugh to replace him, hardcore conservatives now have a firm majority on the court, and some of them have been itching for quite some time to reverse Roe v. Wade, to expand gun rights, religious rights, and more. If there is a new swing justice now, it likely will be Chief Justice John Roberts, but his swings to the left have been rare indeed, upholding Obamacare in 2012, and 7 years later repudiating the citizenship question on the census. SCOTUS blog publisher Tom Goldstein calls the Chief Justice a solid conservative vote. The disagreement among the 5 justices on the right of the court, he adds, have been, how fast do you move? Is the right to abortion going to be struck down? The first place that disagreement can become apparent is on abortion, in a case that asks the court to essentially reverse a 2016 decision that struck down a Texas law making it very difficult for clinics that perform abortions to exist. And now, the Supreme Court has agreed to hear arguments in a case that presents a nearly identical law from Louisiana. Goldstein, who frequently argues cases before the court, expects the conservative court majority to eventually reverse Roe v. Wade outright or to hollow it out. It's coming, he says, but nobody knows whether it's in 1 year, 5 years, or maybe 10. Guns, a major test. At a time when voters seem to approve of more gun regulation, the court seems headed in the opposite direction. Before the court is the first major test of gun regulations in more than 10 years since the justices ruled that there is a constitutional right to own a gun for self-defense in one's home. Court observers have long attributed the hiatus on gun cases to a closely divided court on which neither the 4 conservatives nor the 4 liberals were sure how Justice Kennedy would cast his deciding vote. But now Kennedy is retired, replaced by Justice Brett Kavanaugh, who as a lower court judge was an outspoken critic of gun regulations and a strong supporter of expansive gun rights. How separate should church and state be? Also before the court this term are major questions involving the separation of church and state. For generations, the court sought to erect a relatively high wall of separation, but that has begun to change, and religious rights advocates are poised to pounce. I actually can't recall a time in the last 20 years where there's so many cases ready for decision in this area of the law, says Mark Rienzi, president of the Becket Fund for Religious Liberty. In particular, Rienzi and others have set their sights on invalidating or undermining provisions in most state constitutions that bar direct or indirect aid to religious schools. The mood music at the court is that the justices would probably say that's just discrimination on the basis of religion, and that's forbidden by the federal Constitution, says former Solicitor General Paul Clement. Can an employer fire an employee because he is gay? On another hot button issue, the court will hear a case that tests whether employers are free to fire gay employees because of their sexual orientation or trans employees because of their gender identity. The 1964 Civil Rights Act bars discrimination in employment because of sex. Fired employees contend that language protects them from such discharges. The employers argue that the law was never meant to cover gay or transgender employees. A victory for the LGBTQ community would be huge, says Georgetown University law professor Paul Smith, who notes that discrimination against gay and trans individuals remains rampant, especially in the private sector. The Dreamers. Then, too, there are a variety of immigration cases, the biggest being the Trump administration's attempt to roll back the Obama administration program that continues to protect from deportation some 700,000 to 800,000 Dreamers brought to the U.S. by their parents without legal authorization when they were children. Presidential power and impeachment. Multiple cases are on rocket ships headed towards the Supreme Court, noted SCOTUS Blog's Goldstein. That, he says, is because the president has been so aggressive in asserting his immunity from investigations, whether they are criminal investigations, subpoenas for his financial records, or potentially records related to the impeachment inquiry. The court, as Goldstein observes, is going to hate the idea of tackling these cases in a presidential election year, but they may not have a way out. Faithless electors, the Electoral College, and the 2020 election. And finally, pending before the court is a case that could involve the 2020 election. It's a test of faithless elector laws. These are laws passed in many states and impose penalties on Electoral College delegates, or sometimes provide for the removal of electors who refuse to vote for the presidential candidate of their designated party. The question is, are these laws constitutional? The Supreme Court has never before weighed in on the issue. There have been 167 faithless electors in the history of the United States, and in no case has the outcome of an election turned on the vote of these electors. But there is no guarantee that won't happen in 2020. This commentary is under copyright 2019 NPR https://www.npr.org. The issues noted are reflective of the complexities of our society attempting to deal with a system that was designed for a smaller, slower-moving society through a judicial system not designed for today. The first point is simple. No matter where a justice falls on the political spectrum, at the time the Supreme Court was established, the average lifespan in the United States was 37 years. No one considered a lifetime appointment in the context of a 79.3-year lifespan. According to a recent report by the World Health Organization, we're ranked 31st behind Japan at 83.7 years and 29 other countries. A lifetime appointment, even when conditioned on good behavior, is a different proposal than it was when originated. The basic purpose of the lifetime appointment is to assure the integrity of the powers granted to court justices and to protect them against unwarranted interference from either the legislative or executive branch. The express and implicit separation of the Supreme Court from the other branches of government is therefore upheld in accordance with the principle of providing checks and balances. The executive and legislative branches exercise control over the Supreme Court by respectively proposing and approving candidates for that body. In the highly politicized atmosphere, which has long attended the nominally apolitical arena of court justices, presidents often attempt to buttress their agendas by selecting court justice nominees favorable towards their views. At times, however, the judicial leanings of the court justices prove different in practice than they had previously appeared. The policy of lifetime appointment, therefore, secures a court justice against retribution for decisions going against the wishes of his or her presidential sponsor. The lifetime appointment has never worked that way. The length of tenure has increased over time. We appoint judges, 2 current ones, despite strong cases of inappropriate behavior in sex and other matters. Some judges indulge in unrestrained and possibly inappropriate activities pursuing monetary gain. The opening commentary is entirely based on the very clear and open political divide on the current court, whose upcoming rulings will impact our country for decades to come. A constitutional amendment should allow for removal of a justice from the Supreme Court of the United States for treason, bribery, and high crimes and misdemeanors, including a finding of misappropriation of office through unfair process and appointment. Review of any justice may be requested by a majority vote of Congress, by the President, or may be taken on by the investigating authority without any outstanding requests, but rather by an initial review of the justice that indicates a valid reason for removal may exist. Good behavior is an unacceptably low standard for lifelong appointments, and who determines that behavior is good is very unclear. Read political. I'll discuss my thoughts on the investigating authority during my next program. The U.S. District Courts are currently 13.6% unfilled. Even with 32 appointments pending, it will remain almost 9% unfilled. This appears to be largely the fault of political interplay. I'm not calling for a constitutional amendment regarding lifetime appointments at this time, nor one regarding U.S. District Court appointments, but they both deserve review and consideration. Now let's take a look at the President and his team. I returned from Vietnam in early October 1968, voted for Hubert Humphrey against Richard Nixon, underwent additional operations on my grenade injuries, spent 60 days on convalescent leave, and was honorably discharged in April 1969. In June 1970, with the assistance of the GI Bill, I returned to college. I earned a BA in political science from the University of Kentucky in May 1973. I earned a competitive fellowship from the Southern Regional Training Program in Public Administration, which resulted in my being awarded a Master of Public Administration degree from the University of Tennessee in May 1974. My studies on federal government during that period focused on what was called the imperial presidency. This was a philosophy or belief that the President of the United States could do literally anything and not be held responsible. As President Nixon put it, when the President does it, that means that it is not illegal. As I've noted in previous programs, the Founding Fathers struggled with various ideas of who should comprise the head of state, including dual presidents and tripartite systems where 2 or 3 people held the powers of that office. While they finally settled on having a single individual, they constructed a system of balanced and equal powers to prevent the abuse of powers and ensure they weren't just coming up with another name for a king. They truly were opposed to the powers exercised by one man, in their case King George, and by other monarchs throughout history. They even granted Congress the sole power to impeach and remove the president from office. A strong movement towards impeachment, with the final result becoming inevitable, persuaded President Nixon to resign and stalled the push towards imperial presidency while we stumbled through the Ford and Carter presidencies. The forces pursuing the idea of imperialism didn't go away. They came back with Ronald Reagan and the trickle-down theory of economics granting serious tax breaks to the wealthy. They accompanied this with the Iran-Contra crimes and other questionable actions. This was followed by George H.W. Bush, who campaigned on "read my lips, no more taxes," but was compelled to raise taxes, although not particularly on the wealthy. He also implemented the Gulf War without the approval of Congress. 100 hours of actual fighting, costing about 100,000 lives, and muddling already turbulent waters in the Mideast. The Bill Clinton years intervened without any major military activities, but several questionable actions by the president. Congress tried unsuccessfully to impeach him for lying about oral sex with an intern in the Oval Office. This was a despicable act, highly unethical and immoral, but it didn't rise to the level of high crimes and treason, and Clinton survived impeachment. Barely. George W. Bush was next. This imperial presidency started with someone who didn't win the popular vote being elected president by an act of the Supreme Court declaring it was more important to declare a winner than take a little while longer to actually count all of the votes. It went downhill from there. President Bush downplayed the idea of a potential terrorist attack in the United States, despite one having occurred under President Clinton. We got the Twin Towers crashing to earth. With popular support but no declaration of war from Congress, Bush launched the Afghanistan War, which continues to this day. He quickly transitioned our efforts to include and focus more strongly on Iran, initiated Desert Storm, and flooded the murky waters of the Mideast into such turbulence no one can predict an ending of the fighting. Next came Barack Obama and 8 years of struggling, first with the worst recession since the Great Depression. The Depression had been brought on by George W. Bush and was devastating to jobs in the middle class. Obama struggled to control the Mideast situation and worked hard to restore the economy. He didn't start any new wars. Finally, we come to the current day and Donald Trump. Before reviewing his presidency, the first imperial presidency for real, I think it would be informative to review the fallout from each presidency in terms of legal actions. Executive branch criminal activities by presidential administration. Barack Obama, Party Democratic, years in office 8, criminal indictments 0, criminal convictions 0, prison sentences 0. George W. Bush, Republican, years in office 8, criminal indictments 16, criminal convictions 16, prison sentences 9. Bill Clinton, Democrat, years in office 8, criminal indictments 2, criminal convictions 1, prison sentences 1. George H.W. Bush, Republican, years in office 4, criminal indictments 1, criminal convictions 1, prison sentences 1. Ronald Reagan, Republican, years in office 8, criminal indictments 26, criminal convictions 16, prison sentences 8. Jimmy Carter, Party Democrat, years in office 4, criminal indictments 1, criminal convictions 0, prison sentences 0. Gerald Ford, Republican, years in office 2.4, criminal indictments 1, criminal convictions 1, prison sentences 1. Richard Nixon, Republican, years in office 5.6, criminal indictments 76, criminal convictions 55, prison sentences 15. Donald Trump hasn't completed his elected term. After 2 years and 10 months, his administration had already accrued 89 criminal indictments, 24 criminal convictions, and updated recently 8 prison sentences. He trails only Richard Nixon in criminal convictions, and it certainly appears that more are likely. Just a reminder, my book, Ubuntu, I Am Because We Are, is available on Amazon and wherever books are sold, and presents the only peaceful method available to redirect where we are headed. Check it out on my website, johnkelch.com. That's JOHNKOELSCH.com. Politico released an article on 10/10/19 which outlined the real concern of an imperial presidency beyond criminal indictments, convictions, and sentences. In part, it read, "For the first time, Trump claimed he can ignore congressional subpoenas without offering any legal justification at all. He no longer even pretends to play by the rules." That matters. While the Trump administration has repeatedly taken unprecedented legal positions to delay and stonewall Congress, it previously recognized, however tacitly, the legitimacy of impeachment as a constitutional remedy, even when it prevented witnesses like the former White House counsel Don McGahn from testifying. It provided a fig leaf of justification, executive privilege, or attorney-client privilege, for example, thereby implicitly acknowledging the oversight prerogatives of Congress and its power to issue subpoenas. That changed. Trump announced on Twitter that he directed Gordon Sondland, the ambassador to the European Union, to not appear before the House Intelligence Committee to testify pursuant to the impeachment inquiry. His only justification was that it is a, quote, kangaroo court, unquote, that does not allow the true facts to be revealed to the public. That does not even pretend to be a legal justification for blocking the testimony of an important witness who reportedly called Trump before texting another State Department official, denying Trump had sought a quid pro quo with Ukraine. The administration followed up with a letter to Speaker Nancy Pelosi signed by White House counsel Pat Cipollone, which blasted the impeachment inquiry as illegitimate and an unconstitutional effort to overturn the democratic process. The letter declares that the administration cannot participate in the impeachment inquiry as a result. Calling the constitutional process of impeachment unconstitutional is a brazen attempt to persuade the public that reality is not what it actually is, that up is down and black is white. Call it the alternative facts school of legal reasoning. While the letter is signed by a lawyer and occasionally uses legal terms such as due process, it is a political document, not a legal one. The complaints that the administration has with the impeachment inquiry are not legal reasons that would excuse a failure to comply with the inquiry. Trump is not going to court. He is not claiming privilege. He has simply declared that the usual laws don't apply to him. This is very different than taking advantage of legal procedure to delay by claiming privilege or filing cases in court. Using legal means to cause delay can frustrate the process, but it's not a rejection of the process. In fact, it is often the key to a zealous defense that is essential to our adversarial legal system. Whenever you file your tax return, you can see that you have a legal obligation to pay taxes. Asking for an extension or claiming an unwarranted deduction is very different from refusing to file a return altogether because you believe the U.S. government is illegitimate. Tax protesters who do so are routinely prosecuted and sent to prison. By declaring impeachment illegitimate, Trump seeks to delegitimize the only mechanism by which he can be punished for wrongful behavior while in office. Of all the unprecedented things Trump has done, this has the potential to be the most damaging. The Justice Department has long taken the position that a sitting president cannot be indicted. The reasoning behind the Justice Department's policy is that impeachment is a constitutional remedy for presidential wrongdoing, and that impeachment is a political process, not a legal one. In a recent lawsuit he filed to block the Manhattan District Attorney from examining his taxes, Trump pushed this theory to the breaking point. Trump asserted that not only is he safe from indictment, he cannot be investigated while in office. The assumption underlying all of those arguments is that impeachment is the remedy for presidential wrongdoing. Trump's move on Tuesday aims to take that singular remedy off the table. If he succeeds, if impeachment is delegitimized and ignored, then Trump and future presidents will be truly above the law. The need to clarify and solidify the limits of presidential power is a paramount issue. If we are to remain a democratic republic and not become a dictatorship with no regard for having a government that governs by the consent of the governed, with a commitment to the right to life, liberty, and pursuit of happiness equally for all. Congress passed the War Powers Act as a congressional resolution designed to limit the U.S. President's ability to initiate or escalate military actions abroad. Among other restrictions, the law requires that presidents notify Congress after the goal of avoiding another lengthy conflict such as the Vietnam War. Its effectiveness has been repeatedly questioned throughout its history, and several presidents have been accused of failing to comply with its regulation. The law stipulates that presidents are required to end foreign military actions after 60 days unless Congress provides a declaration of war or an authorization for the operation to continue. Most experts tend to agree that the War Powers Act has rarely worked as intended. According to one study by the Congressional Research Service, presidents have traditionally avoided citing certain provisions of the resolution whenever they submit reports to Congress. As a result, the 60-day time limits of the law have rarely been triggered, and it has never been used to bring an end to a foreign military operation. This act needs to be strengthened and given the force of a constitutional amendment before the war games we've been playing for decades erupt and World War III kills off most of the life on Earth. The current occupant of the White House has demonstrated the need for a clear limitation on executive orders with the force of the Constitution behind it. Congress should be able to halt the execution of any executive order with a successful majority vote in both houses under regular order. Clarification on impeachment is necessary. The constitutional authorization for impeachment allows impeachment for treasury, bribery, high crimes, and misdemeanors. Significant violations of the Emoluments Clause, including the president enriching himself and his family, should be clarified constitutionally as clearly impeachable offenses. Resistance to legal subpoenas to testify before Congress during impeachment considerations should be constitutionally forbidden and subject to immediate imprisonment. Finally, the President's power of pardon should be constitutionally limited to disallowing pardoning himself, his Vice President, any member of his cabinet, any member of the executive branch acting under an unlawful order from the President, and any citizen acting under a public statement from the President directing an illegal act, such as shooting illegal immigrants in the legs to deter them. The concept of our government is based on an equal balance of powers between the legislature, the judiciary, and the executive. Currently, that balance is totally dysfunctional and must be restored. Restoration will not be occurred by electing good people alone. We've been doing that for over 230 years, and here we are. It will not occur by passing legislation, because legislators are unerringly opposed to doing anything to limit themselves, as evidenced in the frequency with which they absolve themselves of having to obey the very laws they pass to limit the rest of us. It can be changed by civil war, but such change is unlikely to leave us any better off. The only truly peaceful way for such change is if we amend the Constitution and focus on a government that governs by the consent of the governed and promotes the right to life, liberty, and the pursuit of happiness equally for all. We have that responsibility. Only we. In my next program, I will present an idea that would change the ability of elected officials and individuals appointed by them to take action strictly for personal gain, to void and break laws, and generally to behave scurrilously. It will be able to hold such individuals accountable promptly, and with a minimum of political consideration involved on either side of an issue. Until then, consider my book, Ubuntu, I Am Because We Are, which is available on Amazon and whenever books are sold, and presents the only peaceful method available to redirect where we are headed. Check it out on my website, johnkelsch.com. That's JOHNKOELSCH.com. Thank you for listening today.